Are you looking to hire an employee or a contractor for that matter? Will the employee or a contractor have access to confidential information that is within your business? You could be a coach, a consultant, or a company for that matter. And at the time of hiring, you may be worried that a particular employee or a particular contractor has access to confidential information. Now, in that case, what do? I'm sure you've read online. The most obvious thing to do is to sign something called a non-disclosure agreement. But are you concerned what are the types of clauses that the non-disclosure agreement should contain? Now, if that's what you're thinking, then well, you're in luck, because in today's video, I'm going to talk about the clauses that every non-disclosure agreement should contain, especially when it comes to working with an employee or working with a contractor. Hi everyone, my name is Ramana Reddy and I am a practicing lawyer in the High Court of Telangana. If you enjoy this video or for general tips, tricks and legal information, make sure you hit the subscribe button below. Now, before we get into what are the clauses that a non-disclosure agreement should contain, let us first think about why you should enter into a non-disclosure agreement. Because there are many coaches, consultants, there are many businesses that hire employees or hire contractors without a non-disclosure agreement in place. So why do you need to enter into a non-disclosure agreement to begin with? Well, the answer to that is pretty simple, because every business has some information that is sensitive, that is proprietary, and it does not want to share that information with any third party. Now, that is why, most people will want to sign an NDA or a non-disclosure agreement. Now, this secret sauce, there could be many examples of this. Let's say, for example, that you're a nutrition coach and, you have these recipes or you have some meal plans or exercises that you share with your clients. Now, if you hire an employee or if you hire a third-party contractor, to work with you, so suppose you have an ebook and somebody's trying to design that ebook, they have access to all this information and there's a chance that they may take it and make it public, or they may start a competing entity and so on. And you run all these risks. Or, it could be something even more basic. If you're a software company, there could be source code. Or if, for example, things that are general, like you may have a customer database that, you don't want to make public. You may have a vendor list, which you don't want to make public, and so on and so forth. So it is important that you have a non-disclosure agreement in place, just so that protect yourself from a third party, and so that he will not leak confidential information that is in your business. Now, the consequence of not entering into one is, tomorrow, let's say that somebody just copies your entire program and they use it elsewhere, then, you may approach a court of law and the court may ask you, why did you not enter into a non-disclosure agreement? Look at your conduct to begin with. You're so careless with information. Why should the court come to your rescue? And, you may have to deal with these type of arguments. So it's always safe to enter into a non-disclosure agreement when you're working with an employee or when you're working with a consultant. Now, before we get into the clauses, let's talk about like 2 or 3 things that you will use to introduce the agreement. Now, the first thing, and that means the most obvious thing, but I've seen it being missed in many cases, which is you have a heading where you will say an employee NDA or a contractor NDA and so on. Because I've seen so many agreements without headings that, and it just drives me crazy, because let's say that you're reading a newspaper and the newspaper has no headlines. You literally have no guide to read the newspaper. You don't know if you're reading the national section, the international section, or your city, sports, and so on. And even if you have, heading, you still need subheadings. Like, for example, you may need a heading for, so you may be reading the international page and you may have headlines under the international page so that actually like what is the news piece that you're reading. Otherwise, you'll just be lost. So the first thing that you need to put in an agreement would be the heading, which is, either an employee NDA or, an employee non-disclosure agreement, or a consultant or a, freelancer non-disclosure agreement, and so on. So that's the first part. This is, again, we're not into the clauses yet. I'm just trying to introduce the agreement. First thing is the heading. The second thing that you will include is you will say, this non-disclosure agreement is being entered into on so-and-so date, but it takes effect on this particular date, which you will define as the effective date. So, for example, it could be in case of an employee, you can say that you may be entering into or you may be signing the document on the 1st of January, but the date of actual appointment could be the 5th of January. January. So you would say, this NDA will take effect from the 5th of January, and that is the execution date. So it is important just to know what is the start date when this employment or this non-disclosure agreement kicks in, just so that there's clarity that, it starts from today. Any information I disclose to you from today, which is labeled confidential, we'll get to that in a second, but any information that is labeled as confidential information from today onwards, you cannot disclose to any other third party. So that is the effective date of the agreement. The next piece for the introduction of the agreement is identification of the parties. You need to specifically identify who are the two parties who are entering into this agreement. So you will say this agreement is being entered into by and between. So you can say, ABC company with registered address, so-and-so company, CIN, the company incorporation number, so-and-so, PAN number, so-and-so, and so on. Now, this is important because, let's say your ABC company, now they can be a company with ABCD, or it could just be, you have your company's ABC in capitals. There's another company called ABC in small letters. So it is important to identify with specificity who, which entity is entering into this agreement. And on the flip side, which is the other party that's entering into the agreement. So let's say you're an employee or a contractor. So you would say that this NDA is being entered into between ABC company, with the details. And you would say, and say Mr. Ashok Kumar, son of so-and-so, resident of so-and-so, PAN number so-and-so, Aadhaar card number so-and-so, and so forth. So that you identify both parties who are entering into the agreement with specificity. So those are the first two introductory pieces. The third introductory piece is where you set the stage for the main agreement itself. So you would say that, whereas ABC company intends to hire this particular employee, this particular employee has expressed his desire to join the company, or the contractor has expressed desire to work with the company. And therefore, since confidential information will be exchanged between the parties, we are hereby entering into this non-disclosure agreement. So that basically sets the stage for the entire agreement. So just to summarize, you have the heading, you have identification of the parties, and then you have the stage that you said, which is, whereas he wants to join a company, we want to offer, and confidential information being exchanged. Now let's get into the clauses. So the first clause that you will be entering into will be where you define confidential information. What is confidential information in your business? Now, what is confidential information will change from industry to industry. So let's say, you are a nutrition coach, for example, then your confidential information in your case could be your meal plans, your exercise routines, suggest some meditation and so on, then so anything, and for example, or otherwise, let's say that you are a software company. So your source code, for example, is your proprietary sensitive information that you don't want to be shared with a third party. So confidential information is, again, a lot depends on the industry type that you're in. But having said that, there are also a lot of common things that you would include within the definition of confidential information. And this definition is important because this is what you're ultimately trying to protect. And so, some of the common things could be, you may have a customer list, for example, you may have a database, for example, you may have some other third-party confidential information. So suppose you're working with another coach or, with another third party who's sharing their confidential information with you, then even that would constitute confidential information when you share it with your employee or with a third-party contractor. Include some other things. For example, if you're working with an employee, you could say your salary is confidential, or you're working with a consultant, then the quantum of fee that I'm paying you cannot disclose that elsewhere. And, that could be confidential information. So, a lot depends on your industry and, all the other things that I just mentioned, which could be common to any industry that you're in. So that's one part of the definition of confidential information. The second part of that definition is it's important to say that, this confidential information can be made available to you, through in a text form, in the form of photographs or in an oral form. So in any form that it is shared with you, that will confidential information. And importantly, that when I share something with you, it does not necessarily, it doesn't have to be marked as confidential information. If a reasonable person looking at that information could infer that it is confidential information, then you must treat it as confidential, because you don't want the employee or the contractor tomorrow going out and saying, but you never told me it was confidential. It was never marked as confidential. So, I'm free to do what I want with it. So, you need to incorporate that within the definition of confidential information to say that if a reasonable person would think it is confidential, then it is probably confidential information. Don't share that with someone else. That's clause number one, where you've defined confidential information. Now, moving on to clause number two. Now that you've defined it, it's important to now talk about, okay, now what is the authorized use? Like, what is the authorized way in which you can use the confidential information? Because there's no fun defining it if you don't talk about how you can use it. And that is important because you're trying to limit the scope as to how the information can be used. Now, under authorized use, the first thing to put in there is that you can use this confidential information only in the course of business. You cannot use it for your personal use, and only in the course of business when we are exchanging information, this is to be used. And in the course of business, meaning in the course of my business. You cannot use it in the course of somebody else's business, in your business, or for your personal use. So that's the first one. The second one you need to put in is that you cannot disclose this confidential information to a third party. And that is actually the reason why we are entering into this non-disclosure agreement, and you have to explicitly state in the agreement that under authorized use, you cannot share this with a third party. The third thing to include under authorized use is to say that as the company or as the coach, as the consultant, I own the right, title, and interest in the confidential information that I am sharing with you. Just because I share it with you, that does not mean that you somehow become the owner of that confidential information. Now, that is the second clause, which is authorized use. First one is how you define confidential information. Second one is authorized use. The third one, which is the flip side of authorized use, is what are the restrictions? Because you've talked about how it can be used, but now what are the restrictions that you have to put in place in the NDA, which is the non-disclosure agreement? So the first thing that you would say is that you need to restrict access. You cannot provide access to any third party. You can only provide access to people who are within the business and within my business, not in third party's business or in your business. Within the business, within my business, you can restrict access only to them and you cannot share it with a third party. The other thing is that, let's say, for example, that as a nutrition coach, you share, here's how to make a diet chapati, for example. So, or you call the chapati almond flour chapati or something like that. Now, the person who is receiving this confidential information should not be able to reverse engineer whatever you've shared with them, like you say a keto roti or an almond flour roti. He should not be able to say, okay, so this would mean that, here are like the 5-6 ingredients that will go in, and I'm going to share each part or each ingredient with a different person, because technically I'm not sharing that it is a almond flour roti that, with a third party, that is part of the meal program. But I'm just reverse engineering it and I'm sharing the parts of that to third parties. So you will explicitly say in the agreement under restrictions that you cannot reverse engineer what I give you. And this would make more sense, for example, like a software company. Like if you have access to a software, you cannot go back home and reverse engineer that entire software and say, I did not make the software public. In fact, I reverse engineered it and on my own, I came up with the software or a copy of the software. So that clause is important. You have to say that you cannot reverse engineer the confidential information that is shared with you. The next one is that if there is reasonable suspicion that the confidential information that has been shared is leaked somewhere, then there is a duty that is cast upon the receiving party of the confidential information, with the employee or the contractor, that he should immediately inform you that there is a reasonable suspicion that the confidential information has been leaked. And the other thing to include is that, that you are the owner of the confidential information, and also that you cannot copy this confidential information onto your personal devices. For example, as a coach or a consultant of the company, for example, if you give the employee, which is not a contractor, but if you give the employee a laptop on which he or she works on, then it's important to say that you can only use confidential information on that device. Or, it could be even broader, for example, like if you guys work on a WhatsApp group and confidential information is being shared within that WhatsApp group, then you explicitly say that you cannot back up this confidential information, on your personal account or on the cloud or copy it to some other device, for example. It should only be used within the WhatsApp group for the authorized purpose. So these are broadly the restrictions that you would have. This is the third clause. Now moving on to the fourth one, which is, this is just to add some factor to the NDA, where you would say, if I find out that you have breached or that you have, illegally leaked confidential information, then I have the power to inform your prospective employer or to inform your next person who's going to hire the consultant that you have done this in the past. So that, and this just creates some fear within the person who's working with you that, if I leak confidential information, not only will I get in trouble here, but this will also prevent me from working with other, with other persons, because if they find out, they're not going to trust me with confidential information. So that's just to add the factor. That's clause number 4. Now the fifth clause is that once the employment period comes to an end, or if you're working with a contractor, once the transaction comes to an end, then they are duty bound to return the confidential information back to you, and they are duty bound to destroy the confidential information that is in their possession. So this ensures that whatever confidential information has been shared with them is not with them anymore and it has come back to you. But having said this, it is also important to keep in mind that if you have given access to confidential information, for example, if you've given access to a Google document, for example, please remove access as soon as the employment or the transaction with the consultant is over. Because if they share that with someone else, then you only have yourself to blame. Although you have an agreement in place, you just don't want to be in a position where you have to go to court and, prosecute and say that, look, he's taken. Even then the court is going to say, after he's done, why did you continue to share it? And he's going to use that in his favor, saying that, this is a circumstance to show that actually the confidentiality obligation was there forever, and so on. Now, the next one is, what is the term of so suppose I stop working with you today, or you stop working with a contractor or an employee today. How long is that information confidential? So you could say from 3 years from today that information is confidential, or this information is confidential in perpetuity, that you can never ever disclose this information to anybody else or to a third party. Now, the next one is, what if there's a breach? That if there is a breach, or if the consultant or the employee leaks information, then what happens? Then you could have consequences in this particular clause, and you would say, suppose there's a 90-day notice period, you could say, for an employee, for example, you could say, I'm only going to give you 30-day notice period. What you've done is just wrong. Or if it's a contractor, that's even better. You could say, if I suspect that you have leaked confidential information, I'm going to issue a legal notice to you, and 7 days from the receipt of that legal notice, if you don't give me a good answer, I'm going to terminate that relationship there and then. And this is something that's captured in writing, which is always a good thing. Now, the next one is, what is the governing law? Which, for example, if there is a breach and you want to sue the contractor, you would say governing law is India, obviously, but also you would say, which particular court would have jurisdictions. I mean, I'm in Hyderabad, so I would say a Hyderabad court. If you're in Delhi, you'd say a Delhi court. In Mumbai, you'd say a Mumbai court. Or you could just go opt for arbitration, which is generally a faster process than approaching the courts. So just to summarize these 7 clauses, the first one to include in an NDA is, to define confidential information. The second one is authorized use. How do you use that information? The third one are the restrictions that you place on how it can be used. The fourth one is that you can inform a prospective employer if you find out that the person you're working with has breached the confidential information. The fifth one is that if there's a breach, then I can give you a shorter notice period. And the sixth one is governing law. I hope this video was helpful. If you enjoyed the video, please consider hitting the subscribe button below. Thank you for watching.